I will now call 123-825 State of Kansas versus Jones.
May it please the court, Joseph A. Dash, appearing on behalf of Byron K. Johnson. I'd ask to reserve 2 minutes, please.
2 minutes.
Thank you, Chief Justice.
The appellee in the state of Kansas through Wyandotte appears bind through Garrett Rel. That's the oral argument.
Mr. Dash, whenever you're ready.
This is a post-conviction appeal based on illegal sentence for a criminal history scoring error. This appeal centers around the proper application of case law for a period when Mr. Johnson's case was sentenced on November 17th, 2011. I'm going to skip to the part I really want to get to, and then I'll come back.
When you're skipping to that part, Mr. Depp,
sorry.
why don't you help me understand what was the law
Oh, thank you.
on November 17th? What was it, 2011,
Yes,
when he was sentenced?
yes, Justice.
Williams was had been ruled on, but the application of Williams was done differently based upon pre-1993 crimes that carried no non-person designation, and those that didn't, versus post-1993 crimes.
Yes, Your Honor.
So what was the law in place at the time of sentencing?
I would say simply enough, it was Williams. That was all we had to work with.
And Williams, that time, delineated a distinction between pre-1993 crimes, followed Vandervoort. I assume you're familiar with that. And then for crimes that were post-1993, followed the Williams in the designation of person, non-person.
Well, Your Honor, and I appreciate what you're saying, and I'm not trying to,
Essentially, that's what the Court of Appeals found.
yes, they did. And I think that let me actually, I would say, and I'm going to be completely blunt, Vandervoort is the most overblown, analyzed decision that did not say what everybody thinks it said. It said one thing. It said that the person or non-person, it actually dealt with whether a person could be a misdemeanor or a felony based on the time of the prior incident. And that's all it really said was it was an unspoken thought that when are we going to choose to use the comparable statute? And they defined comparable as more simply as the most comparable offense, which eventually got changed in Wettrick later on. We're not talking about Wettrick though. Let me go ahead and go back and do what I was going to start with.
I'm sorry,
Maybe it'll make
go
more
ahead.
sense.
I should have
No,
interrupted.
I didn't mean that, Justice. I was just, you got me a little, stopped me short, but I understand why. I'm going to focus on the primary conviction since criminal history is only applied to that count. This case was a slow mover. There are 3 dates that are important here. The offense was sometime between October 8th and October 6th, or October 8th, 2005 and October 6th, 2006, or maybe October 8th, but might be a typo. But 2006 is the date of offense. Mr. Johnson was not charged for 4 years until 2010. So the statutory scheme we're talking about is what was in effect in 2005 and 2006. So that's why this became a pre-Jessica's Law case. So we're talking about a 2005 statutes. And that particular statute that we're getting into right now is 214711E in the 2005 version, which started back in 1974, I believe, is when we got that one. No, that's not right. I apologize. That's not correct. It was in effect. The 2005 version is the correct statute. 21-4711E was the reason, the way that we interpreted the out-of-state crimes. That's all we had. That's one of the reasons we have Murdoch, is because Murdoch says, well, we can't put things into the statute that aren't there. And that's one of the problems with 4711E. So getting back there, so the 2011 conviction was for rape, level 1 offense. And he received a 272-month sentence based on a C criminal history, which was uncontested. Although the judge only asked the defense counsel, and the defense counsel were answered. There was no detailed question to the defendant about his criminal history, which isn't a
Let me
stopgap.
just,
Yes, sir.
just clarify that
Yes,
in 2011, part of the criminal history C designation was based upon prior out-of-state convictions pre-1993
yes,
that were scored as person felonies, correct? And that's what you're saying, that's wrong. They should have been non-person.
correct.
But I just want to understand, that's what we're dealing with here is out-of-state pre-1993 convictions that were scored as person felonies.
And the argument, and the argument is we're adding something to that 1992 statute that doesn't exist, a classification. It wasn't there. There was no person and non-person. It was at that time, I believe what we're talking about was it was a B felon.
Yeah.
Yes, sir.
Would you agree that Williams was not directly on point on this question? In other words, the actual holding of Williams did not extend to pre-93 out-of-state conviction.
I think it was more vanilla than that. I think it extended to all pre.
Well, that's not what it said, is it? I
Well-
mean, I'm asking about the actual hold, the facts of Williams. Williams wasn't dealing with a pre-93 sentence.
No, it was not. It was not.
So in Murdoch one was dealing with that and actually made a holding on pre-93 out-of-state sentences. Is that correct?
Yes,
Would
I
you
think-
agree with that?
Yes, I do.
So
I do.
that's just a lead up to my question, which
Yes.
is, do you know whether or not there were any Court of Appeals opinions that were squarely on point on this question after Williams and before Murdoch one?
I'm not aware of any published opinions, but I mean, most of those followed Vandervoort, which I believe.
So even if they're unpublished, so that, I mean, I guess that's my question. Why wouldn't those Court of Appeals opinions, if the Supreme Court had been silent on this crucial question, why wouldn't the Court of Appeals opinions, why wouldn't we look at those to determine what the law was at the time of this sentence?
We should.
And if those Court of Appeals opinions indicate that at the time of this sentence, the law in Kansas was not to apply Williams to pre-93 convictions, then that would mean this was a legal sentence at the time it was rendered.
With all due respect, I think we're splitting hairs with the pre-93 distinction. I don't think there's that much of a distinction.
Except the Court of Appeals said that's what they did. I mean, you look at the Court of Appeals decision in this case.
Yes.
They said they distinguished between the two, and that's what they relied on, and holding that your client doesn't prevail. Because the Court of Appeals said that during this time between Williams and Murdoch, there was a distinction made between pre-1993 prior history crimes, out-of-state prior history crimes, and post. And what the Court of Appeals said, as Justice Stegall just alluded to, is that it was treated differently. That was the law, at least according to the Court of Appeals. And do you know of any cases where that holds? But that's what they said, was that they were treated differently. And what was treated differently was Vandervoort was applied to pre-1993 crimes in this time period versus Williams post-1993 prior crimes.
Well, then I would believe that the Vandervoort court and the Court of Appeals in this case is guilty of putting something in the statute that's not there.
But that substantive issue is not in front of us, is it? I mean, the only question is whether the sentence was legal when it was pronounced. So I think what this court's struggling with is what was the law at the time the sentence was pronounced, not whether that law is right or wrong, because we've already resolved, I mean,
obviously.
we've resolved a lot of that in
Right.
cases, but those came later. So the question is, what was the law at the time?
I would say that Williams was the only law that we can really look at. And I think that we look at the statute that was in place at the
But
time.
that's not how it was actually. I understand that argument. Are you making that argument in the face of the fact that actually Vandervoort was what was being applied, and you're just saying that was in error?
And I will continue to say this, Vandervoort was overread and it was not, the holding of Vandervoort was very, very narrow.
Let me ask this will be my last question on this. If we assume for purpose of the question that it's actually true that the Court of Appeals, the precedent at the Court of Appeals level was to apply Vandervoort to these kinds of situations, would you agree or disagree that the district court in this particular case was bound to follow that precedent?
I would say they were bound to follow what Williams was rather than Vandervoort. Because I think Vandervoort exactly
The
was
district
not.
court should have ignored the Court of Appeals precedent to do something different.
I think they should have followed this court's rulings, not necessarily any other Court of Appeals. Now,
isn't the issue, Williams is decided in what, December of 2010,
yes,
and this sentencing is November of 2011. So the issue, plain and simple, is just whether Williams is the controlling law in place at the time the November 2011 sentence on Mr. Johnson was pronounced.
and that is my argument, Justice Miles. And I understand that each one of the three of you answering the most questions are the ones that authored these opinions. And so we have Murdoch 1, which it was your opinion, and we have, so I think we have a court that has a lot of knowledge in all of these cases, which is great.
Is
Uh,
it significant that the Court of Appeals Murdoch panel decision was in September of 2011? So that panel decision just,
You're getting beyond my, I'm sorry, Chief Justice, you're getting beyond my recollection of Murdoch, and I apologize for that. But I guess it would be significant, except for that when this court accepts a case, then the Court of Appeals decision is gone. Just like it is here.
kind of falls within that murky time period where that had not yet happened.
That's
Which
right.
presents a procedural issue because, we had not granted review
Right.
until May of 2012. So and probably by the time of this sentencing, it's conceivable, I didn't double check the dates, that a petition for review hadn't even been filed or
Well, it would have had to have been filed, I would imagine, if the decision came out.
days of the deadline probably. So-
Right. This whole problem really comes because the Sentencing Guidelines Act is the most litigated piece of litigation in Kansas, litigated piece of legislation in Kansas criminal law. And why? It's a runaway train. It grows and grows and grows, and we're not ever getting back to the whole point, was supposed to have truth in sentencing. And every time this court makes a decision, or every time the Court of Appeals makes a decision that the legislature doesn't like, they add more. They just keep adding and adding and adding. But sometimes they're missing the places where they should be putting things. And so we have these holes, like 4711E, that just doesn't have anything.
Argument from this court on that point, so.
I have made my point today, I suppose. But after Murdoch 2, we do know that the train stops on the date of sentencing or when the sentence becomes final, depending on how we look at that. I know in Justice Stiegel's opinion, you have said that post-conviction cases do not apply the finality of the case does not apply to post-conviction motions. And so in this case, it really doesn't matter because the motion was filed long after the decision, the case was final. And but we also had Williams in effect right at the time of the decision or the sentencing here. So
I need clarification on.
I'm sorry, Aaron.
I need clarification on that point. I still can't get over, I think the issue here is whether Williams in 2010 from our court applies. I guess I don't really care what the Court of Appeals was doing. Because that's not the law. The issue is going to be whether Williams controls, I think. Let's assume we decide Williams does not control your client's November 20 sentencing. Is there any other argument that you have you need to consider to get you where you want to be? Or does that mean that Vanderbilt's there and you're sunk?
I think that means that the Vandervoort, which I still say is being
I
overread.
don't care. I
Okay,
mean,
I'm sorry. No, I
and
don't.
think everybody's saying it doesn't matter whether certain law that existed at the time was right or wrong. It existed. The question is what's controlling, good or bad?
Okay, in the instance that Williams doesn't control, my client loses, period. But I just don't think that Vandervoort was a controlling precedent for this type of case because Vandervoort did not address that issue as part of its holding.
Well,
It addressed it in the dicta. It was assumed, but it was not a key element. It was simply part of that case that just happened to happen.
And isn't that true of Williams also? I mean, that wasn't part of the Williams holding either. I mean, in a sense, both of those cases controlled in that they were both controlling precedent. Maybe to refine Justice Biles' question a little bit, it's Supreme Court law is controlling precedent, but did it answer the question?
I think that's fair. Neither one answers the question directly or completely.
doesn't Murdoch 1 tell you that Williams answered the question? Because Murdoch 1 says this result is dictated by Williams. And then in Murdoch 2, we said the same thing. And in Keel, we said the same thing.
Well,
Reference to Williams' impact on the Murdoch 1 decision.
well, Justice Biles,
It just seems to me that if Williams controls the Murdoch 1 outcome, it's the controlling law.
that is my argument here, is that Williams actually just was the law and Murdoch just happened to say, and by the way, this hole is here. And with this hole here in the statutory scheme, we can't add things to it.
Would you agree or disagree with the statement that prior to Murdoch 1, the controlling interpretation of Williams would have been any Court of Appeals opinion?
If there was something in between Williams and Mr. Johnson's sentencing, sure, but I don't think there is. I'm not aware of it. And that doesn't mean there isn't one somewhere in there, but I don't believe there is one in that short period of time.
That's because you dismissed Murdoch 1. The Court of Appeals panel of Murdoch
Yes,
1.
yes, I didn't dismiss it.
Well, I understand, but that you would put it in the category of not controlling.
If it helps my client, I would, but at this point, I really can't do that. I can't argue that. I mean, certainly I can't say that. I'm sorry. I wish I could, but like I said, it's very murky on when controlling precedent comes out of the Court of Appeals. And while I'd like it to be precedent a lot of the times, once that petition for review comes up, we're done. Well, I won't get into my other cases, but
No, counsel, part of the frustration that I think everybody has is the advocates don't make a consistent argument. Whoever's standing at that podium is making the argument that gets the best outcome for their client. Williams and Murdoch being a great example. The state argued for the outcome in Williams.
Yes.
In Williams.
Yes.
And then when Murdoch comes, they said, oh no, Williams is wrong. And the lawyer on the other side happened to be the lawyer for the defendant in Williams and said, I told you guys when you argued that principle that this was going to happen.
Right.
And so this law is in such flux that it's, really have to get past what are good arguments and just look at, what's the law and live with it.
And just about, I think I agree with you. And this case presents some weird situations because we have the time of crimes was in 2005. The sentencing was in 2011. his appeal didn't get docketed for 7 years. So that's 7 years of case law is what's making this very difficult to argue and very confusing. And maybe not confusing for you guys, but it's very confusing for me and the court. I apologize.
Well, the failure to docket the appeal was not your client's fault,
No, absolutely not.
but it doesn't change. I mean, still, the outcome is Murdoch 2 says the controlling law at the time of sentencing. Debate we're having now is what was the controlling
I
on
understand.
November of 2011.
And I would have to say it's Williams. There's nothing further. I'll sit down.
Thank you, Mr. Desch.
Thank you.
Rolf?
May it please the court, the state of Kansas appears with the appellee, Wyandotte County, Garrett Ralph. Judge, I'm sorry, justices, I think there are a couple things that do need to be clarified with regards to Vandervoort, because the issue does seems to be what the law was at the time of the sentence, and I think everybody agrees on that. Whether it was Vandervoort in the defense or the appellant has argued that it's overruled or it's overread, overused and misinterpreted. And he said today that Vandervoort only dealt with whether or not something was a misdemeanor or a felony. Not completely accurate. Vandervoort dealt with 2 issues. One was he had 2 convictions in Virginia from 1980, one for exposure, and that was what was dealt with. He had 2 convictions that are very similar in statute. One was a person felony. The other one, the issue was whether it was a person felony or not. So they looked at the 2002 statute at the time to see if it was comparable. On appeal, it was conceded that it was the most comparable. So the issue was whether or not that was person felony was addressed there. And then in a second part, the argument under Vandervoort was that it shouldn't have been a person felony because when it was charged from 1996 to 2000, the state charged a range of offenses. He actually committed, in his own statements, 50 to 60 molestations. In 1996, when it was the beginning of the range, ag and decent liberties, as the statute was the most comparable, was a Class B misdemeanor. In 2000, final conviction or the final instance, it had been changed to a level 8 person felony. The problem is that the jury did not distinguish between whether or not it was a 1996 instance that arose to ag and decent liberties or whether it was 2000.
Counsel, let me sort of at least cut to the chase that I think may matter. I heard your opposing counsel, I think, concede that neither Vandervoort nor Williams actually rendered a holding on this key question of pre-93 out-of-state convictions. Do you agree with that?
The holding, yes.
I mean, certainly, this is what the bread and butter of the lawyer trade is, to argue that precedent dictates a future outcome. But if you don't have a holding that's squarely on point, that's all you can do, right? I mean, you can argue from Vandervoort and the reasoning there, or you can argue from Williams and the reasoning there. But the bottom line is we're stuck with a circumstance where in 2011, there was no Supreme Court opinion that answered this question. Do you agree or disagree with that?
I agree that that question was not particularly raised.
Well, it wasn't raised and it wasn't answered. Again, of course, lawyers can argue from precedent to say, based on this precedent, the outcome now ought to be XYZ. But my point is there was no XYZ in 2011.
I agree. There was no Supreme Court case that dealt with that. As
Do you have a case in which we talked to Mr. Dash about this? The Court of Appeals in its decision in this case said that pre-1993 out-of-state convictions, which Williams didn't apply to directly, were treated differently than the Williams scenario that had post out-of-state convictions post 1993 and applied Williams. The Court of Appeals said in this case that they were treated differently, and there's some case support for that. Do you have case support for that?
Yes, Judge.
And what is it? That seems to be at least important to me. If you can point us to a case where that was the law in November of 2011.
Judge, as cited in the case that this court ruled on, State v. Adams, it was an identical case and cited the rulings in Murdoch 299 can at 316, then State v. Mitchell, it's at 275 P3D 931. It's unpublished Kansas Court of Appeals case. Then State v. Mims 260 P3D
Give us
1248.
the dates of those cases as you're going.
Yes, I'm sorry. 2012, 2000, State v. Mims is 2011. And then State v. McKinney is 2010.
And those all stand for the proposition of what you're proposing, is that there was a distinction in how out-of-state convictions pre-1993 were treated.
Yes. And
That's
said
the
you
string
said state-
site from Adams, right? That's what you referenced.
I'm sorry.
Oh, sorry. Go ahead.
I think it's the same. You said Adams was a decision of this court and it was a Court of Appeal. Adams is a Court of Appeals decision.
Yes, I apologize. I misstated.
And I think when I looked at that string site, the only one that fell before the sentencing in this case was Murdoch 1. Is that correct? Or did I miss one?
No, I believe it was the one that, and I apologize for interrupting.
I'm sorry, just to clarify my question, I meant Murdoch in the Court of Appeals.
Yes, I believe Murdoch 1 was the only one that officially came before.
I thought you referenced the 2010 case.
2010 was State v. McKinney.
And what was the holding of McKinney?
Justice Steele, I apologize. I know that it is in the
That's
string
okay.
site.
That's an in the weeds question, I
I
understand.
don't believe I have that one with me. But to-
And are those decisions? Because actually law prior to a mandate issue in there, does the court need to look then to whether a petition was filed triggering a rule that would stay the mandate? At least pending a decision on whether this court would have taken a petition or denied it? Do we have to tack that time period on too?
Judge, I'm not sure on that. Either I'm not understanding your question, or I don't know if I have the information.
So
to
it
give
is
to
a
you.
Court of Appeals decision controlling just once it's published, if there is a petition for review filed, and under our rules, the mandate of the Court of Appeals would be stayed if a petition for review is filed.
Yes, I agree, Judge. I'm sorry, Justice. Apologize.
I think what Adams pointed to McKinney, point out the difference between the handling of cases before 93 and after. And McKinney dealt with a 2002 Oklahoma conviction. So they were saying it was an example that fell after the 93. And then they contrasted that with Murdoch, which was I'm not sure McKinney helps you.
I would argue that it helps in how it was the difference in treatment that the cases were handled. As Justice Biles said, one of the issues we have is whether or not the specific question was asked. And like in Vandervoort, the specific question on whether or not pre-1993 felonies that were committed should be treated as the same as the current law. In Vandervoort, that's exactly what they did, though. While there was no question that was raised, that's specifically and exactly what they did. They looked at the 1980 Virginia law and applied it to the sentencing that occurred in 2002. Not only that, they then looked at the law that applied in 1996 when one of the offenses was, or some of the offenses were alleged to have occurred. They actually overruled the sentencing at the time and had it remanded for a lower classification, since it could have been a misdemeanor, giving him only one person felony. So at the time in Vandervoort, they did apply the statute of the out-of-state conviction and then looked at the law as it was occurring in the Kansas law at the time of the current crime.
But when I read Vandervoort, there were two issues presented, okay? Issue one, is it comparable or identical? And they went to the statute and said, look, they don't have to be identical, they just have to be comparable. So this is going to be our holding. It's comparable, not identical. And then the second issue was, which we've since overruled, is that it's, we're going to look at, for purposes of when to do that comparability analysis, we're going to look and see, should we use, historically, they use the date of the sentencing. They said, nope, we're going to use the date of the commission of the crime. And those were the two issues presented, and those were the two issues decided. And any kind of other result that came about as a result of deciding these issues is basically dicta, right? And even then, then you have Williams that comes down later. And those, that the issues presented there were post 1993, after the sentencing guidelines came into effect. So how does that affect, even Vandervoort, really? Because Vandervoort had to do with pre-1993. So I don't really understand. I'm kind of jumping off where Justice Stiegel went, and really where you and your opposing counsel are, what your points are. It's, the law was really confusing, but because Williams wasn't on point and Vandervoort wasn't on point, we're looking here at an armed robbery conviction from 1992, trying to determine whether that's a person felony. It's armed robbery. And I know what we're looking at is what law applies, but really our narrow issue of what we're looking at is to your point about the Vandervoort. So how does Vandervoort apply? Do you really still think Vandervoort applies, or you think it's clear that Vandervoort applies and isn't distinct?
I believe that Vandervoort applies in the methodology that was used to address the issues. When they used the conviction at the time, the law at the time of the conviction versus what it is at the time that he was convicted of the new crimes. They did that twice. They did that both for the sentencing, but they did it also for when he was convicted. That's how they actually looked at the law, I guess, 3 times. Two issues, but on the issue of whether it was misdemeanor or felony, they looked at the law twice because it changed during that range that he did. I would argue that Williams was, you can argue, as controlling law, but it was not on point to what the issue was here. Williams addressed on the factual basis was simply post 1993. It happened to be a post 1993 conviction, 2001, 2002, and said, no, we're going to go with what the law is at the time of the conviction.
Counsel, let's say that this district court judge gets this question in 2011. What am I supposed to do? Is this person non-person? So district court judge says, I want to call a recess. I want to go do a little research. And judge goes back in his chambers and types in some stuff, and up pops Williams, Vandervoort, and the Court of Appeals opinion in Murdoch 1. Which case should the district court judge have followed?
Murdoch 1, if it occurred after Murdoch 1,
Well, we know all
Supreme
three.
Court.
No, we know all 3 of those opinions were filed and available.
Right.
Williams, Vandervoort, both Supreme Court opinions and Murdoch 1 Court of Appeals opinion. And that's what the judge is looking at. I mean, this is the question. How is that district court judge supposed to know what the law was?
We'll look at both Vandervoort and Murdoch 1, the Kansas Appeals opinion, because it was on point.
And only one of those three opinions addresses the issue squarely.
Squarely, Murdoch 1 addresses the issue, correct? And Murdoch 1 says, this is how we've been treating it, and this is how it's going to be treated going forward. That was later overturned by this court. But at the time, that's what the law was.
Well, and the Murdoch panel did cite to other panel decisions that have preceded it. But they're all unpublished. And so we have both the Murdoch panel and these other panel decisions are all unpublished Court of Appeals decisions. So we don't have, I don't believe, I haven't seen a published Court of Appeals opinion on point. I have at least 3 unpublished Court of Appeals. Let's say, you look to see if they're comparable. What would the comparable classification now in effect be? Now in effect being the time of sentencing. That time we classified it as a person or a non-person.
Correct. Did you? Apologize, Justice, Chief Justice. Were you asking me a question there, or
I was just.
or
I
just
think-
explaining what everybody should have realized what the law was, or what that judge should do?
No, good point.
Okay,
I
just making sure.
think she's telling us we should.
I- And I liked what you
I
said,
guess,
so I'm not going to say much.
I
but-
guess my question would be, what do we do with the fact that they are unpublished opinions? We do not have a published opinion.
The fact that they're unpublished means that they're persuasive. And to correct an illegal sentence, the sentence would have had to been against what the law was at that time. There is nothing to say that the law wasn't what the district court ruled and what the district court sentenced. Maybe unclear based on your interpretation of prior cases, but there is nothing to say it was an illegal sentence at that time.
Then what do we do with the statements from this court that I mentioned to defense counsel, where this court said Williams 1 controlled the outcome in Murdoch 1, and then that was repeated in Murdoch 2 and Keel as being the controlling law, dictating the result. If a district court judge is sitting there trying to figure out what dictates the result that I've got in front of me,
I would contend that Murdoch 1, and the reasoning that was used, it overturned the law, as was stated by the appeal or the opinion in Murdoch, said we're overturning all Court of Appeals and district court rulings. It was a change in law.
but was it? If our court is saying in the analysis that Williams 1 is dictating the result in Murdoch 1, Williams is controlling what happens in Murdoch 1, and then we repeat that same notion in Keel and in Murdoch 2, it seems to me Williams is the controlling law coming from this court in a published opinion. What's wrong with that?
One of the arguments in Williams can be argued that it was controlling, that at the time of the conviction, you have to look what the Kansas law was. The issue becomes, pre-1993, of course, there was no designation for person or non-person felonies. So then the rulings that were made by the appellate courts going up to that said, we understand what Williams is, and Williams says effect. However, it's not on point. So then you look at what the Kansas law is at the time of the new crime, whether it's a person or non-person felony. Murdoch said, no, that's not what we're doing. And we're overturning all these decisions that have come before.
Based on Williams.
Based on the principle of,
Based on Williams. I mean, I don't think you can wiggle off of that. Murdoch 1 is dictated by how Williams was decided.
I don't disagree with that. I don't disagree that it was instrumental. In fact, I believe Murdoch 1 said in its opinion that this is what we told you could happen in Williams. And that if the legislature wanted to address the issues, the difference or that 1993 was not classified as person or non-person, they can do that.
Shouldn't that be persuasive to our district court judge in November of 2011 who's trying to decide what the law is?
But at the time, they didn't have Murdoch 1 from the Supreme Court. Other questions?
Yes, you reserve 2 minutes.
Yes. I just wanted to address a couple of things. Justice Standridge, you mentioned that this is an armed robbery, and yes, it is obvious. However, we're talking about sloppy legislation that did not point out and if we're going to talk about pre-1993, and I'm not trying to be crass or anything like that. We're talking about pre-1993 comparisons. There is nothing in the statute that says, how do we compare these and what time do we compare these? And that was the problem in Murdoch. That was the problem in Williams. That was the problem. What point of reference do we compare these statutes? And what is in those statutes and what's not in those statutes? In this particular thing, nothing from 92 and below had a person or non-person designation, period. Armed robbery was the same as something that wasn't armed. Well, the armed robbery was not a person felony because there were no person felony, period. We came up with this in this legislation in 1993, or that became effective in 1993. And I'll be honest, I was in college when this stuff happened. In 1992, Blaine Carter came to my criminal justice class and told me, this is going to solve all of our sentencing problems. We're not going to have any more sentencing discrepancy. Black kids are going to get the same sentences that white kids do. And that was the point in 1992. That's not what's happened. Not at all. We've got just a big mess. And it's a big mess for a reason. They didn't do their homework, apparently.
You know what the difference is in what?
In this particular case, it's 48 or 58 months. So roughly 5 years on the top end. On the low end, with 15% off, it's 48 months, 4 years or 5 years. And truthfully, in Mr. Johnson's case, it may not make a difference because he might die. He probably will die before he hits that time, either one. Because he's 60 now and his out date right now is presently 2038. Make it 2035, that's 12 years from now. So
Pradesh, so I suppose, triggering off Justice Standridge's point, we're so entrenched in looking at bad or serious violent felonies as person felonies, because that's what they're classified as under the sentencing guidelines. But even if a felony is legally declared to be a non-person felony, the sentencing judge can still look at an armed robbery and say, that was really bad, that was violent, and within my discretion, I'm going to lean towards counting that against the defendant as much as possible. So you can still consider it whether or not it's classified as a person or non-person felony, right?
yes, but, and I might just say, he or she cannot change the level of a crime.
Right.
So that's the problem with our sentencing guidelines situation.
Can't change the designation of a non-person or person based
Right.
upon the act. I mean, it's either a person or a non-person based upon the guidelines and
Yes.
how it's designated.
Yes,
The problem we run into is when it wasn't designated pre-1993 and how we handle that. You can't change a person
That's
or
correct.
non-person designation.
So
Yes.
classification is black or white, person or non-person for the
Af-
pre-93.
after 1993, yes. Yes. I'll make one last point and I'll sit down here. I just asked this court to think about this for a moment. Why did Keel overrule Williams? Why did it see the need to overrule Williams? Is that because of the target date? Or is that because Williams did something that triggered Murdoch 1? Well, Murdoch 1, you said was wrong in Keel. Williams, for some reason, was also wrong. What was that reason? And then I think we have answered our question. And that's the point I wanted to make, and I apologize for being cavalier. I'm not trying to be, but I can see that we have a bit of a division in the court for a reason. And I think now you guys get to slug it out. Thank you.
Thank you, Mr. Dash. Thank you to both counsel for your arguments this morning. The court will take this appeal under advisement.